Legal Liability. Can I be sued? Chapter 10 of Kimmer and Walsh. One of the primary questions in all educators' minds is, can I be sued? The more important question is, can I be held liable? Anyone can sue at any time, but what we want to know is our legal liability and what can we do to keep ourselves above reproach legally. There are two categories of legal liability. Criminal liability, which involves crimes against the state, is the first, and penalties for this range from heavy fines to imprisonment to death in some states. We will be more concerned with claims arising out of civil law. We will be discussing the law of torts, which are civil wrongs against another that cause the injured party to go to court to seek compensation. There are many kinds of torts: defamation, negligence, assault, and invasion of privacy. In the educational setting, negligence is the most common tort. In Texas, we have the general legal principle of sovereign immunity. To hold a school district liable under state law, the plaintiff must point to some specific statute that allows the courts to impose liability. The Texas Tort Claims Act spells out circumstances under which a governmental entity in Texas can be held liable for personal injury. Regarding school districts, the only way liability can be imposed is when the injury arises from the negligent use or operation of a motor vehicle. The state of Texas affords strong protection for educators. A certified educator cannot be held personally liable for any act that is incident to or within the scope of the duties of the employee's position or of employment, and that involves the exercise of judgment or discretion on the part of the employee. For qualified immunity to attach, the professional employee must have been acting in the scope of their duties, exercising judgment or discretion, must not be using excessive force in disciplining students, must not have been negligent when disciplining students, such as to cause bodily injury, and qualified immunity does not apply to operation, use, or maintenance of motor vehicles. Excessive force in disciplining students, being negligent when disciplining students, or operating motor vehicles, and the problems that could come from that, are the areas in which educators must be very, very careful. Because of this, many school districts have abolished corporal punishment. The Texas court interpretation is liberal in order to protect school professionals. In Stout v. Grand Prairie ISD, the court stated, if competent people are discouraged from entering the teaching profession because of potential tort liability, the public education system will be adversely affected. The position of the courts is also that the taxpayers should not have to bear the burden of liability because they have employed a wrongdoer. Educators are also immune from liability for administering medication in the school if the school has a policy permitting it, if there is a written request from the parent, and if the medicine is in the original container and is labeled. Educators are also immune from liability for reporting drug activity within the scope of their duties. Official immunity applies to professional employees who are performing discretionary duties such as coaching, extracurricular activities, extracurricular sponsorships in good faith. Again, corporal punishment is an area that can be dangerous for the educator. Realize that you are not protected if a child is injured through corporal punishment, such as bruise, such as puts their hands behind them before you paddle them and maybe break a bone in their hands, bruise their hands. Even if the parent is given permission, that permission is only a piece of paper if the parent decides the child has been injured and holds the educator liable. My personal advice as a former principal is never, never to engage in corporal punishment. The risk is just too great. Confidentiality laws are spelled out explicitly. Parents are entitled to all written records. Other school personnel can review records if they have a legitimate educational interest. Information may be disclosed to a governmental agency if disclosure is required or authorized by law. Before information is divulged, contact your attorney. It may be that you would be better protected if you ask that a warrant be issued for the information. If there is a probability of imminent physical injury to self or others, this information may be disclosed to medical or law enforcement personnel. Never lead a student to believe that you will not divulge what you're told. Let the student know there are some cases in which you cannot keep information confidential. 1983 suits are those in which the litigant is accorded the right to hold every person liable who has deprived the litigant of rights protected by the Constitution or federal law. Examples are freedom of speech from the First Amendment or freedom from unreasonable search and seizure from the Fourth Amendment. Therefore, qualified immunity or official immunity do not come into play when a right protected by the Constitution or federal law has been violated. The test questions for 1983 suits are as follows. First of all, is the right constitutionally protected? If the answer is yes, then did a school administrator who had the authority to correct the problem know of the misconduct on the part of the employee? Was the administrator deliberately indifferent? And did injury to the student result? We have gone over much legal information in this class, and there's even more out there that would be valuable to know. How can an educator know it all? The standard of knowledge is that the educator should have basic knowledge of the key concepts of law. Not knowing is not a defense. Governmental liability attaches when the official responsible for establishing the final governmental policy for a particular activity makes a deliberate choice from among several and authorizes an unconstitutional act. Monell v. New York City Department of Social Services determined, however, that proof of a single incident of unconstitutional activity is not sufficient to hold the government liable unless there is proof that the incident was caused by an existing policy from a governmental policymaker. This would pertain to a school board of trustees and is one reason that legal advice for board actions is so very critical. The information on liability should be of some comfort to educators. Unless an action has to do with motor vehicles or student discipline, you probably will not be found liable. The courts seem to understand how difficult it is to be responsible for groups of children day in and day out and want to offer protection in exchange for competent individuals wanting to go into education. Remember, however, that you can be found liable for infractions against constitutional and federal rights, such as freedom of speech, etc. Many of the cases we have discussed this semester fall under this category. Much heartache and distress can be avoided if you will first of all take the time to get advice and think through decisions, and secondly consult central office personnel and or the district attorney.